Hello, and thank you for joining us for the first episode of the Practical Patent webinar series. This episode will discuss docketing and docket management for U.S. initial filing, provisionals and regular apps, due bar dates, Paris Convention, and PCT deadlines. This is the first episode in a 4-part series. A recording of the webinar and the slides will be made available to all registrants. Feel free to enter any questions using the Q&A feature in the Zoom menu. They will be addressed in a Q&A session at the end of the webinar. We invite you to follow us on LinkedIn to see news about other upcoming webinars. And with that, I'll turn things over to our moderator.
Thank you, Michelle. I'm McCrackin. I'm the president of Black Hills IP. I'm a patent attorney with 24 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years, and I was also a full-time law professor, and I directed the patent prosecution program at Franco Law Center in Concord, New Hampshire. Black Hills is an innovative US-based company that uses technology to help law firms and corporate legal departments implement a streamlined best practices approach to legal operations. I am fortunate to have with me today the docketing manager from both Schwegman as well as our docketing manager from Black Hills IP. So Z, can you introduce yourself?
Hi all, well, welcome to our first episode of this webinar series. My name is Zhakalazky Carrion, and some know me as Z. I've been at Schwegman for 16 years, straight out of college. Started as a receptionist, then moved to case manager. A few years later, moved to paralegal, and finally landed in the docketing department, which I ended up finding my calling. I've been managing the docketing department for almost 8 years. So I hope you enjoy what we have prepared for you.
Thank you, Z. Ellen, tell us about yourself.
Yeah, hello, my name is Ellen Franco. I have been with Black Hills IP for 6 years, and I have been managing the docketing department for the past 3 years.
Great, well, thank you both for joining us today. Let's go to the next slide. I'd like to start off actually with 2 polls just to get an idea of what our audience distribution is today. So we'll launch the first poll and give you a few seconds to answer what your role in your organization is.
And we'll give the poll about a minute, so we'll give it about another 30 seconds. Thank you everyone for voting. And about 10 seconds left. And I'll end polling. And here are the results.
Okay, so we have a mix in our audience, docketers and paralegals, few attorneys and managers in there as well, and then some other backgrounds. That's great. This webinar will have something for everybody. I understand that a few people will be newer to the docketing role, and we have some basics, but not too basic. And then we have some other things a little more advanced, and my goal is to have something that everybody can take away regardless of your role and your experience. So let's go to the next poll. I would also like to get a sense of what docketing systems our audience works with. So let's take a minute and enter the docketing system that you work with.
And we'll give it a few more seconds for the poll. And we'll close it up in about 5 seconds. And I'll stop polling and share the results.
Okay, so quite a mix on these results too. Looks like the two most common will be Foundation IP and CPI. And then a decent amount of IP Manager, Memotech, and Anaqua as well. Okay, that's really helpful just to know what the types of systems are that the audience is using. So let's go to the next slide. In this webinar, we're going to be focusing on the docketing for initial US application filings. The three main areas we will cover are what deadlines need to be docketed. There'll be some basics in here, but not too basic. We've got a few little advanced things as well, a little bit of trivia in there. And then how are those deadlines docketed? We've got a checklist for you, as well as just some process tips. And then finally, I can't emphasize enough the importance of priority dates when we're talking about deadlines and docketing US applications. So we're going to spend a fair amount of time talking about the priority dates and their role in the docketing process. So why are these deadlines important that we're dealing with today? Well, the deadlines associated with and docketed at the time of the new application filing can be particularly problematic because some of these deadlines are unforgiving. If you miss them, they can't be recovered or they're very difficult to recover. Some of them can be tricky to docket. And sometimes even if you properly docket them, you can inadvertently dedocket or cross them off. So these are really important deadlines, and we're devoting the entire webinar to the US application filing docketing. So let's go to the next slide. Just real quick terminology, again, to make sure that everybody's on the same page. When I'm talking about initial application filings, our focus today will be on the US provisional applications and then US non-provisional applications. Just due to time, we don't have enough room in this program to get into PCT filings, even though that could be your initial filing in some instances. We're really going to go deep into US provisional and US non-provisional application filings. And again, to make sure we're all on the same page with terminology, the filing date refers to the date the application is filed. Then we also use the term priority date throughout this program. And the priority date is the earliest filing date in a family of applications. Now, in some instances, you have only a single application, and in that case, the priority date and the filing date are the same. So if you're docketing a provisional application, the filing date is the provisional application. The filing date of the provisional is your priority date. If you're docketing a non-provisional and that was your first filing, the priority date is the filing date of the non-provisional. But we'll use the term priority date throughout. Just recognize that in some situations, your filing date and your priority date are the same. And then keep in mind, and don't forget this because we have some questions throughout the program, and there's one that's going to need this little bit of knowledge. If you're docketing a non-provisional application and your earliest filed application was an international application or a foreign filed application, your priority date would be the filing date of the non-US application. So don't forget that. That one's going to come up again later. All right, next slide. So for the first portion of the program, as we focus on the deadlines to docket, I like to think of these in two categories: pre-filing deadlines and post-filing deadlines. So when we're talking about pre-filing deadlines, we're dealing with bar dates. When we're talking about post-filing deadlines, we're dealing with the deadline to file a non-provisional application claiming priority back to a provisional, or foreign filing deadlines like your Paris Convention deadline or your PCT deadline. And then it's worth noting the national stage deadlines in this program as well. So the big difference between the pre-filing and the post-filing dates, to me, is that the pre-filing bar dates can change. They vary depending on your circumstances, like a client's announcement that they're going to offer, a client's offer for sale of a product, for example, could possibly change the bar date or add a bar date where there wasn't a bar date that needs to be docketed. Whereas in contrast, the post-filing deadlines aren't going to change. Those are calculated and dependent off of a filing date or a priority date. So let's now take a look at these deadlines. Z, can you talk about bar dates?
Well, as you mentioned, Anne, pre-filing deadlines are bar dates. And what is a bar date? So in order to prevent a patent from being ruled invalid, it's going to be essential that the US patent application be filed before 1 year has passed after public use of the invention, an offer for sale of the invention, or disclosure of the invention in a printed publication of general circulation. So it's important for you to at least file a provisional patent application, or you will be prohibited by the law from filing a patent application for the invention. And that is why it's very important to docket this type of pre-filing deadline, which we know as a bar date. And as stated under the 35 USC 102B, an applicant has 1 year from the date the invention is first offered for sale or publicly disclosed to file a patent application. This rule is very unique to the US because foreign countries require that no public disclosure takes place before filing. So it's possible to file a foreign application from a US application, but however, to do so, this is going to do, the US application must be filed before any public disclosure or sale. That's the bar date.
And if we could go to the next slide. Here's a summary of what Z just described. Now, I'd like to move on to the next slide, which is another polling question. I'm curious how our audience gets bar dates on the docket. Do you rely on the attorney to tell the docketing department, or does docketing reach out to the attorney? How do you make sure you get those dates? Because they are so critical. Let's answer the poll and see.
Thank you everyone for your participation. We'll give the poll about 30 seconds, so about 10 seconds more. And I'll go ahead and end the polling and share the results.
Okay, so the over 2/3 of the audience just rely on the attorney to tell the docketing department if there's a bar date. But we have a number of people who have a process to actually reach out to the attorney to try to get that date on the docket. And Z, I know at Schwegman, you have a process to proactively reach out to get bar dates on the docket. Can you describe how you've implemented that at SLW?
So we have a monthly report that comes out, and with all of the matters that were open recently in our system, and then we touch base with the attorneys to see if they have been made aware of any bar dates by the client. And we follow up until we receive an answer if there are bar dates to docket or not. And that way, we also make sure that there are no newly matters open in our system that are lingering without someone paying attention to them. And just wanted to do as a tip that since this letter is pretty much the same, it's like a little survey question. This is a template that you could create and send automatically to attorneys. So you are not creating this letter constantly, and you end up getting a response from the attorney if a bar date is needed, or if we need to docket a target in our system, a target date in our system.
That's a great tip, Z. And for those of you who don't have a more formal process to get bar dates on the docket, you know, this is one thing you may want to consider from a process standpoint to add to your to the way you handle the pre-filing deadlines. Let's shift over to post-filing deadlines. Ellen, can you kick off this discussion?
Absolutely. There are several post-filing deadlines that need to be on the docket. The first post-filing deadline that needs to be on the docket that we are going to talk about is the provisional conversion deadline. This deadline is for provisional applications to be converted to a non-provisional application. This needs to be done within 12 months from the filing date of the provisional application.
Now that seems straightforward enough, but there's a couple wrinkles when it comes to docketing provisional application deadlines that not everyone may be aware of. So let's go to the next slide. And Z, can you walk us through these special situations?
So these are deadlines to claim priority to U.S. provisional applications, which we also know as post-filing deadlines because our system was the one that generated the deadline. So we have the non-provisional application that was filed more than 12 months after the filing date of the provisional application. But let's always remember 12 months is super important. But in case something happens something that was not your intention, and you miss those 12 months, you have actually 2 extra months to file a petition, and with a pay to, you also have to pay a fee. And you have to explain that it was unintentional that you filed this application after the 12 months. And this is a little scary because you don't really know if your petition is going to be granted or not, but it's a possibility. You have this extra 2 months to be able to file this petition that needs to be granted. Now there's another date that also systems might docket, and it's the Bayh-Dole Act, or Patent and Trademark Law Amendments Act. And this is a 10-month government conversion deadline. That this deadline only applies for inventions that are funded by the federal government. So it's a permit government contractors to retain ownership of the inventions developed with federal funding. So something to keep in mind, that it's not something that will get docketed in every matter that you file.
Those are interesting, Z. And I noted that you said that the 14-month date that petition was a little scary. I'll just add, though, that it's a lot better than it used to be, because when the Patent Office created the concept of a provisional application back in, I think, the late 90s, originally that 12-month deadline was absolute. If you missed it, you were dead in the water, and there was no possibility of restoring. And so this is a more recent concept. And if you've been practicing, you know, the amount of time I have, you might not know that there is now this 2-month period with the possibility to restore if you find yourself in a bad situation. So we wanted to make sure everybody was aware of that. Okay, let's go to the next slide. Ellen, let's keep talking about these provisional applications.
Provisional deadlines are especially important because the USPTO doesn't notify you of the provisional expiring, signifying the end of the 12-month conversion deadline. This means any accidental cross-offs or dedocketing of this 12-month deadline needs to be discovered as quickly as possible, either before the 12-month deadline or within that 2-month grace period, or there is no chance to keep the original priority date. If you miss filing by that 14 months, you cannot file a petition to restore this priority date. Provisional applications, they don't receive many USPTO communications. So every time you receive a communication, it is important for you to check that they are set up correctly on your customer number and in your system. Any communication you receive after filing is an opportunity to ensure that 12-month deadline is docketed correctly in your system.
Those are good tips, Ellen. So we've talked about provisionals. Now let's talk about foreign filing deadlines, which are another big category of post-filing deadlines for initial US application filings. Zia, I'll hand this one to you.
So we have two foreign filing deadlines, and it's the Paris Convention deadline and the Patent Cooperation Treaty that we all know as PCT deadlines. The Paris Convention is an international treaty that is going to allow the applicants to file a first application in their home country. And that application is referred to as a priority document or filing, and the date it's filed, it's called a priority date. So the priority filing starts a 12-month period within which a further application called as Paris Convention application, or also as a direct application claiming priority, can be filed elsewhere and claiming Paris Convention priority back to the priority date. So to the extent that the content of this Paris Convention application is disclosed in the earlier priority document, it will be backdated to that priority date. So we have to be mindful about these priority dates when we're putting them in our system. If the Paris Convention didn't exist, then that means these applicants would be would need to coordinate simultaneously filing in all these other countries, and potentially it's going to create more cost. And imagine the cost that you would have in translation. So that's a plus on the Paris Convention. And Patent Cooperation Treaty, again, PCT deadlines, this is kind of like the Paris Convention, but it's an international treaty. And also, like the Paris Convention, it's going to allow the filing of a single application in the applicant's home country while preserving the rights in other countries. So there are benefits on this because you get a little bit extra time than what you have in the Paris Convention deadline, because in Paris Convention you have 12 months, and for the PCT you end up having 31 months in some countries. And we'll talk about the timelines in future slides. But you have the 31 months in some countries that are after the priority date or the initial date of that PCT application filed. If it didn't claim priority to a Paris Convention application, and the application must enter the national phase in each country or region of interest. Also, I want to mention that this PCT stage, you end up, it's kind of time for you to prepare, give you an opportunity to prepare your application for you to be able to get into these other foreign countries that you want to file your invention in. So it's kind of like an examination up front before you go into the national stage in other countries. So really, in the summary, the PCT is a time buying exercise, and even though it does end up being a little bit expensive, you do end up getting a little bit more time. Like I mentioned, 2.5 years versus 12 months from doing from going the route of the Paris Convention.
Okay, thank you, Z. So one important thing to note is that the Paris Convention shouldn't be confused with the PCT. These are two separate treaties. And the difference really is the PCT is the equivalent of filing separate patent applications in multiple countries. You have that 12-month period that the Paris Convention gives you to do your foreign filing, and then the PCT allows you to satisfy that foreign filing deadline with a single application, rather than having at that point to file in all, 5, 10, 12, however many countries you're going to file in. So now a little bit of trivia. My next slide is another polling question. Is Taiwan a member of the Paris Convention?
And about 15 seconds left in the poll. And I'll go ahead and end polling.
All right, good. The majority got the question right. Taiwan is not a member of the Paris Convention. This used to be years ago a favorite question on the patent bar because it's a tricky one. So not all Paris Convention countries are PCT member countries. And then there's some countries like Taiwan that are not Paris Convention or PCT. So if Taiwan isn't a member of the Paris Convention, it means you don't have the 12 months to file. But we all know everybody files in Taiwan a year after the US filing. So how does that work? Well, in a handful of countries, Taiwan is one of them, probably the most common. There's a few others. Fiji is another one. In a handful of countries, there's actually an agreement, a separate agreement between the United States and that particular country, establishing priority between the two countries that allow you to do your filing in that other country a year after your US filing. Now, where this is important, for Taiwan, but also for countries that are non-PCT countries, but they're Paris Convention members. So Argentina would be a good example of that. So when you're docketing the foreign filing deadline off your initial US filing deadline, at that 12-month point, you need to make sure that that when you're satisfying that foreign filing deadline, that the attorney recognizes that a PCT application does not cover all potential countries. And there may be some countries like Argentina that's only Paris Convention, or Taiwan that isn't even Paris Convention, that if the client intends to file in those countries, they have to do that at that 12-month foreign filing deadline on the docket. They cannot wait until the end of the PCT process because that country will no longer be available to them at that point. Okay, so there's your little bit of trivia about Taiwan and the Paris Convention. Let's keep talking about foreign filing deadlines, and we'll go to the next slide with a few tips. Like the provisional, or the deadline for filing a non-provisional application, the USPTO also does not notify the applicant that a foreign filing deadline is approaching. So you have to make sure that you've captured that deadline on your docket. Once you go past that foreign filing deadline, it's extremely difficult, and in some countries nearly impossible, to recover your foreign filing rights. Particularly Japan is an extremely difficult country to file in if you miss your foreign filing deadline. Germany is another one that can be quite difficult. And even in some where you can file and recover, you still tend to have to pay a hefty fee and put some statements in the record that you may not want to put in the record about why you missed that deadline. Also, you should always keep in mind accidental cross-offs or de-docketing, because oftentimes if a foreign filing deadline is accidentally removed from the docket, you don't necessarily discover that by the 1-year date in time to recover and do the filing. So you may lose your original priority date in that instance. And then finally, from a docketing standpoint, keep in mind that foreign filing deadlines for Asian countries are obviously different time zones. And if you have a foreign filing deadline in Asia, it's already passed when you get to the last day, and the day that the deadline is probably showing up on your docket. So, Z, I'm curious with respect to deadlines in Asian countries. I have seen some organizations that will docket the foreign filing deadline a day early, or docket maybe a reminder a day early to address this issue of the time zones differences. How do you handle this in your docketing department?
So in our system, we docket the day that it is. We don't docket a day before, but we do have a procedure in place that it's a daily docket report that we contact the attorney and the paralegal a day before the deadline for all foreign countries, just to take note of what you mentioned of the time difference with Asian countries or other countries that are not here in the content of America. So we always do a day before ping to the attorney and the paralegal, but we definitely in our system docket the day of the final deadline.
Okay, so you docket the actual deadline.
Exactly.
All right, well, the last thing I would like to cover on foreign filing deadlines is the 30 and 31 month PCT national phase deadline. Now, I said we weren't covering PCT application filing, so why do we include this one? Well, this deadline is important because it keys off of the priority date. And I said priority dates are so important in docketing or new US application filings. And this deadline is generally calculated from your priority date. So it's worth noting here. And Ellen, can you talk about this?
Yeah, another post-filing deadline that you need to ensure is on the docket correctly is the 30-31 month national phase deadlines. These deadlines are for going national stage into other countries based on the PCT application that is filed within 12 months from the priority date or filed directly. The 30-31 month deadline is based on the priority date of the PCT application. So it is especially important to know the correct priority date of PCT applications.
Good. Let's go to the next slide and see how this looks from a timeline standpoint.
Yeah, so this graphic does a great job of illustrating the Paris Convention 12-month deadline and the 30-31 month national phase deadlines. Depending on the countries and the filing strategies you'd like to use, it's important to have both deadlines on the docket. Countries a part of the PCT have significantly longer to file, whereas countries that are only part of the Paris Convention have a significantly shorter amount of time to file.
Okay, and those are definitely critical deadlines. So let's just summarize. And Z, can you give us a summary of the deadlines to be docketed for initial US application filings on the next slide, please?
So here's a little summary of everything that we've been talking, right? The post-filing deadlines are going to be based on your earliest priority date or the filing date if there's no priority date. So we have the provisional conversion deadlines, the foreign filing deadlines based on Paris Convention, and the PCT Chapter 2 deadlines, which we know as national stage. Regarding the provisional conversion deadlines, we have 12 months from the earliest priority date or the original date of the filing date of the application. Then we go to the foreign filing deadlines based on Paris Convention. If it's a design patent application, we know that we have 6 months from the earliest priority date. Let's not get confused with the normal utility application, which is 12 months. So for designs, it's 6 months. And then we have 12 months from earliest priority date for the utility patents. So here in the utility patents, we have continuation in parts, applications with new matter. But just please keep in mind that when you have an application with new matter, the foreign counterpart is, or foreign filing is only for that new matter, not for the whole application. So something to keep in mind. And here I am, we added a link to the list of all of the Paris Convention, all of the countries that belong to the Paris Convention Treaty. And earlier you made that poll about Taiwan. When I was working on this slide, I didn't see Taiwan in here. I was like freaking out. And yeah, so I learned something new too, Anne. Thank you. And then we have the PCT Chapter 2 deadlines, which are the national stage. We have 30 months from the earliest priority date. And please note that there are some countries that aren't just 30 months. I pointed out here some 30-month countries can be EP, Australia, Korea. For China, they have 32 months, and for Bosnia, 34 months. Now, we provided here a link with all of the timelines, but I did want to make a note. Even though in China we have 32 months to enter national stage, there is a time limit applicable if the applicant pays an additional fee for the late entry into the national phase. So you do have 32 months, but you do need to have in mind that you will pay additional fees for these extra months that you're using. So just something to keep in mind.
Great. Those links are really useful resources because those are maintained by WIPO and they are kept up to date. If a country is added and joins the Paris Convention or the PCT, those lists get updated. So I recommend bookmarking those. They're great resources. Thanks for including those, Z. Now, I want to take what we're looking at here and just flip the perspective because it will help lead into the next part of the discussion, which is how these deadlines are docketed. So this is looking at what the deadlines are. Now let's change our perspective and think about if you're docketing a provisional application, that's your first US filing. The deadlines here that would apply would be you should have on your docket a 12-month deadline to file the non-provisional application. You should have a 12-month deadline to file a PCT application. And then that's where a little bit of docketing philosophy comes into play. Some docketing departments will just have a single 12-month deadline for foreign filing. Another option is to break that out and have a 12-month deadline for PCT filing, and then a third 12-month deadline to cover the non-PCT countries like Argentina and Taiwan, for example. If you don't break that out, you just need to make sure that there's an understanding within your firm or your department that there are some countries that need to be direct filed at that 12-month deadline and the PCT doesn't cover them all. Then similarly, if what you have in front of you to docket is the filing of a US non-provisional, and that's the first application filing, you don't have obviously the 12-month deadline to claim priority back. Instead, you just have the 12-month foreign filing deadline that would either cover PCT plus everything else, or you have a 12-month PCT filing deadline and then a 12-month foreign filing deadline for Paris Convention and other things like Taiwan. All right, you can tell I used to be a professor because I have another polling question. And these are getting progressively harder as we go through the program. I can't wait to see how you guys do when we get to the final question that I have because it's one of my favorites. But let's start with this one. So let's launch the poll. So now we're starting to think about things from the perspective of the docketer and what's going on in your docketing department. So when you're dealing with a new application that was filed, so we're talking about the post-filing deadlines, what dates are the dates that are actually entered by the docketer into your docketing system, FIP, CPI, whatever it is?
And it looks like we have a few more votes coming in, so we'll give it about 15 more seconds. Okay, so I'll go ahead and close the polling. And here is how people voted.
Oh boy. Okay, good. We got something to talk about here. So the correct answer is the second answer. For most docketing systems that I saw in our poll at the beginning of this program, it would be number 1 and number 2. So let's talk real quickly about how docketing systems work. Typically, The docketing systems that I saw and that I had listed in the poll that are docketing systems designed for IP docketing have country law rules that will calculate the deadlines that we're talking about, your foreign filing deadlines, your provisional conversion deadlines. And so your docketer is not having to calculate those 12-month deadlines or 30 and 31-month deadlines themselves and enter them. Instead, the way it works is your docketer enters the filing date, and if there's a priority date that's separate from the filing date, the priority date, and then the docketing system uses those two dates to calculate the provisional conversion deadline, the foreign filing deadlines. So generally you would have a docketer entering the first two dates on that list, and the docketing system would be using those to calculate the second or the third and fourth date on the list. So let's now look at a checklist for steps that a docketer would take when docketing a new application. We'll go to the next slide. And Ellen, can you walk us through some checklist items for docketing a new application?
Absolutely. When docketing, it is a good idea to always follow a checklist so that each time you're ensuring specific items are correct. Here we have a sample checklist for new applications filed. With this checklist, you want to verify the file type to ensure it matches the type of application that is being docketed. Enter the earliest priority application number and date if applicable. Enter the application number and filing date of the current application. Verify the foreign filing deadline launched 1 year from the earliest priority, or if the application has new matter, then 1 year from the filing date. Verify the non-provisional conversion deadline launched 1 year from the earliest priority if applicable. There are probably a number of other items you could add to this checklist, like confirmation number, inventors, etc. But right now our focus is related to future deadlines. We will cover formalities in the next episode.
Okay, so there's two interesting things here that well, there's a lot of interesting things, but two things I want to point out. The first one is that verify file type. We haven't talked much about file types, but docketing systems have different types, file types for records, and that might be, you know, a non-provisional application, a provisional application, a PCT application, a trademark application. There's different types of files that are usually identified when you create the record in the docketing system. And that's important because typically the country law rules that calculate those due dates that we talked about are tied to the file type. So if you have an application that's a provisional application, but when you open the record in the docketing system and you don't identify the file type as a provisional application, you call it a non-provisional, or worse yet, you call it a PCT. It probably won't launch the 12-month deadline to convert the provisional to a non-provisional application because that file type was wrong. So file types are particularly important, and it's you need to make sure that you have the correct one in the matter that you're docketing into. Then, Ellen, you introduced another new concept here in that fourth bullet where you talked about whether or not the foreign filing whether or not the application has new matter. This is another spot that varies in terms of how docketing departments handle this, and it's actually not necessarily something everybody knows, that when you have a provisional as your first filing, and then you file a non-provisional, many of us know that oftentimes the content in that non-provisional will be a little different than the original provisional application filing. So if there is new matter in the non-provisional application, the new matter only portion of that application has an additional 12 months, or basically 12 months from that non-provisional application filing to file foreign applications just on that new matter, not on the matter in the earlier provisional. So Z, I have a question for you because I see different practices on this. Some people will docket a foreign filing deadline off of a non-provisional application, even though there was a prior provisional application. Do you do that at Schwegman?
So we changed our policy. No, we don't do that because we end up filing based off of the priority date, just to make sure that we do not miss a deadline. Because like I mentioned before, that foreign filing is only applied to the new matter that was added to the application. So if you end up doing like a deadline based off of the filing date of that application, then you might be missing on your priority date. So just, I think a couple years ago, last year, we ended up changing it to just be based off of the priority date, no matter if there was new matter or not.
Yeah, and this is something that varies from one department to the next. I know some of the customers that Black Hills dockets for have docketing systems or docketing processes where they do docket a 1-year foreign filing deadline off of a non-provisional, even though there had been prior provisional. And that sometimes causes confusion though, because if you had a provisional and then at 12 months you filed a non-provisional and you did your foreign filing, which is what you should, but you also docketed then another foreign filing deadline 12 months later, oftentimes the attorneys looking at those dockets get confused and say, I already did my foreign filing deadline. Why is this on here? Well, the reason it's on there, if you choose to follow that approach, is because, maybe one time in 100, there is new material in that non-provisional application that you want to cover with additional foreign filings that was not covered in the initial foreign filing. And that's where it matters, if that new material was not included in the initial foreign filing. If you have that on the docket, it at least makes you think and ask the question so that you don't overlook that opportunity. Most of the time you don't need it, but once in a while, you may want to have that there. So it's a good thing to think about in terms of your docketing procedures, if that's a deadline you want to docket or not. Okay, so Ellen, thank you for sharing that checklist. That's very useful. Let's now go to the next slide and start talking about priority dates, because we've been mentioning them throughout this program, and priority dates are very important. I can't emphasize enough how important they are, because oftentimes if you have an error in one of these deadlines associated with your initial application filing, it's because of a priority date error. So when and where are these errors likely or more likely to occur? Well, the two spots that I see them are in the file opening process, and generally for a single application, or when you're dealing with a intake or file transfer situation with a large number of files coming into the organization. So common errors when you're doing a routine file opening could be that the filing date has a typo in it, for example, or you miss the priority date and only put the filing date in. Or when you're dealing with an intake, you have to be particularly careful because sometimes prior counsel data maybe doesn't include the priority date, even though there is a priority date, or the priority date may be wrong. So there's lots of issues that can come up. And one particularly tricky one, Z, can you talk about the next slide?
So talking about diversity of priorities, and not just diversity, it's an application that claims priority to a variety of applications. And that's when it becomes tricky, because all of us are like, oh yeah, it's based off of the priority date. But when it becomes tricky is when you have more than 2 or 3 provisionals that you need to claim priority to. Sometimes you have 5 provisionals. So which one are you going to pick as your priority date? And it's very important because throughout this webinar, we've been talking that priority is very important. And these post-filing deadlines are being launched or docketed based on these priority dates. There's no issue, right? When an application was filed for the first time, well, you know that that application date is going to be your date that's going to launch all your other dates. But when you have priority dates that you need to pick from. So all of your other dates get launched correctly. You just need to be very careful and mindful which one's the one that you pick.
Good. That's really important. Thank you, Z. Okay, told you the questions are getting harder. We have another polling question. So let's launch the poll. Assume you're opening a file in your docketing system for a new US non-provisional application that was filed today. And it has 3 priority claims in it. Your docketing system has a field for priority date, which we know is important. Which date goes in that priority date field when you're docketing this new application?
And it looks like we have lots of answers coming in. So we'll give it about 15 more seconds. Okay, and I'll go ahead and end polling.
Good. You guys listened to me. I gave you the answer in one of the first slides in this program, and that is that if your first filing in a family of filings is a international application, that is the priority date. Sometimes there's confusion that the first priority date would be a US priority date, but when we're talking about these deadlines for initial US filings, the priority date needs to be the first filing in the family of filings. So in this example, that happens to be an Australian application. And so the correct answer is the May 1st, 2020 is what you should have entered in your priority date field. Okay, let's go to the next slide. So let's talk about some tips for making sure that you have priority dates correct. First, when you're docketing any kind of foreign filing deadline, obviously you need to verify that the priority date that's used to calculate the deadline is correct. So one thing that you might consider is auditing the priority dates in your system. Black Hills does a lot of audits like this. There's different ways to do this, but you know, if you have a lot of priority dates that you're trying to audit, it would take you forever to manually go through and look them up one by one. What we can do is take the data from PAIR, give us, you know, go into private PAIR and scrape the priority date information, and then compare that electronically to the priority dates in the docketing system. It's much faster, more efficient way to do that check. You know, we've in some recent audits that I've seen our analytics team do, we've seen as many as or as high as 2 to 3% of the priority dates in the docketing system having some kind of discrepancy. You know, a discrepancy doesn't necessarily mean that the date is wrong, but it could be. So, you know, let's put some numbers to that. If you have 5,000 pending US applications in your system, 2 to 3% would be 150 that have potentially erroneous priority dates. Even if you have 500 pending US applications in your system, 2 to 3% is 15, and even 15 is more than you want. So, you know, what kind of discrepancies are out there? Well, common things we see are filing dates entered in the priority date field, or a parent application. If you have multiple, you know, you have a long priority string, the immediate parent being entered as the priority date, but that's not the priority date. The priority date is the earliest priority date. Then there's the obvious transposed numbers, or, you know, if you have priority dates that are in European date format that were copied and pasted, you know, all kinds of things like that come up. So it's really a good idea to audit your priority dates. And then also be very careful about dedocketing. It's easy to inadvertently cross off a post-filing deadline like this. And you have to have some kind of check or verification. At Black Hills, we have an automated verification process that will flag what I would call suspicious dedocketing of critical deadlines like foreign filing deadlines. So if you think about this, if you have a application that's been filed and the foreign filing deadline is crossed off 2 months after the initial application's filed, seems a little odd that you'd be taking that deadline off that early. That's suspicious, and we'd electronically flag something like this. I often get asked, what about these docketing systems that have some kind of discrepancy reporting function within the docketing system? And there's many of them. One that comes to mind is CPI. That's not the only one. There's several. Can you just rely on that? That's okay, but it does have some limitations, and you need to be aware of what those limitations are. So for example, those systems are just doing an electronic compare against a data set somewhere. If the application number in your docketing system is wrong, or maybe not wrong, but is in a non-standard format, it might not match the public data that you're trying to match up against, so it might not catch it to even check it. Or worse, it might match it against a different application number, and we see this in some foreign countries' data. So you get a more complete audit if you have it done where you have someone who can normalize those application numbers, go through and look at those discrepancies, and make sure that you're getting as complete of a check as possible. However you do it, make sure you audit those priority dates because they're critical. Another practice that's essential is, everybody should have some kind of a backup docket for non-recoverable post-filing deadlines, these foreign filing deadlines. And then automate your docketing process. This is an easy way to avoid a lot of these issues, because many of these issues are human errors. And if you automate your docketing process, you reduce that human error potential. And so, what does that mean? Well, there's a couple different levels that we're talking about. There's systems like AppCall that allow you to provide an application number when you're opening files, and they will go out and pull in the bibliographic information from private pair, for example, and basically bring in the filing date and the priority date information rather than having you or your docketer manually key that information into the docketing system. Another thing is there's capabilities out there, and Black Hills has this capability to extract those critical dates from the documents that are being presented in the docketing process, so that, again, those dates are not manually keyed into the system. They're being extracted from the documents and put into the docketing systems. Regardless, if you're moving to an automated docketing process, which is where I think the field is going over the next 5 years, more and more people will be using automated docketing, it's critical that you have a docketing system that has an API that's available and can be connected to by other docketing systems. So the ones that I know of that have very good interoperability that would allow you to bring data in from other systems or work with vendors that can provide automated docketing services would be systems like Patricia, available from Patrick's, CPI. Many of the people on this call had CPI. Several of the systems available through CPA Global and Clarivate, like Foundation IP, IP Folio, Improtec. I think they all have good APIs and can be connected to. And then AppCall's another one that's a great value and has good interoperability. If your system's not on that list, it's going to be difficult for you to move to more of an automated function. So those are some tips for preventing issues with priority dates. I have 2 more polls that we're going to do real quick. Actually, given time, Michelle, let's skip the next poll about backup dockets, and let's go to my favorite question. I want to go to this one and see how everybody does on this. Okay, so this is the last poll. So assume you filed a US provisional application 1 year ago, and you're filing the non-provisional application today with no new matter. and it's claiming priority to that provisional application. What's the correct due date that should be launched in your docketing system for the foreign filing deadline?
I see answers keep coming in.
I can't wait to see them.
So lots of answers coming in now. We'll give it about 15 more seconds. Okay, and we'll go ahead and end polling.
All right, I'm proud of this audience. That's excellent. The correct answer is today. You better be filing that your foreign filing applications today, or at least PCT application today. So one common mistake though that I see, and this is why I asked this question, is that sometimes people think that the foreign filing deadline is based off of the non-provisional deadline. But you guys know, because you've attended this webinar, that your foreign filing deadline is based on the priority date. And in this example, when you docketed that non-provisional, or when you docketed the provisional application, the priority date would have been the filing date of the provisional application, which was April 1st, 2020. Your docketing system would have calculated a foreign filing deadline off of that for 12 months. So you should have at that point used the checklist that Ellen walked us through and confirmed that the foreign filing deadline launched, which would have been April 1st, 2021 today. And also that the non-provisional conversion deadline also launched for April 1st, 2021 today. So those would have both been on the docket. If you had used today's deadline or today's date, April 1st, 2021 as the priority date, you'd have the wrong foreign filing deadline because it would be a year out in the future, and that would be incorrect. And the October 1st deadline is the 30, I think if I did my math right, that's the 30-month deadline, which is also incorrect on this. Okay, cool. Let's go to the next slide, Michelle. All right, so today we've talked about the foreign filing deadline, or we've talked about the deadlines for U.S. initial application filings. We talked about what they are, talked about how to docket those, and then we also really drove home the importance of priority dates. So I know we're at the end of our time, but if people want to stay on, we're happy to take questions. You can put your questions in the Q&A button on the Zoom interface. And if you don't have time to stay on for the questions, we will be emailing the slides and the audio recording of today's program to the attendees. They will also be posted on the website for both the Schwegman Lundberg firm and also on the Black Hills website. So let's see what we have for questions. And we have a lot of questions. I'm not sure if we'll be able to go through all of them, but let me go and kind of pick through some of these. So I have a question. What would be the best practice to obtain the bar date or the pre-filing bar date? And I think, you know, that was Z, you had talked about that, where the docketing department facilitated that and proactively reached out to confirm if there was a foreign filing or if there was a bar date for the initial filing, right?
Yes, correct. We would contact the attorney. And I would just advise if there's a lot of bar dates that you need to touch base with the attorney, or you are the attorney, maybe you ask the correct questions to your client too, so they are able to tell you if a bar date is needed for their invention or not.
Here's an interesting tip. This person says, for foreign filing reminders, our docketing staff sends the client an automated reminder that specifically mentions Taiwan and Argentina as examples. So they're making sure that the client, not just the attorney, but the client is aware of those deadlines with some automation. I love that. Okay, let me keep going through here.
Could I take one of the questions, Anne, regarding?
Yeah.
So it says, we have noticed that in opening new matters for transferred in files, it is tricky to get the correct priority date entered for docketing PCT application deadlines. Any tips for how to verify these dates on transferred in files? We do a lot of, like, thousands of transferred ins at Schwegman, and transferred ins can become a headache because it wasn't an attorney that you can turn around and ask them if they filed, what was it that they filed. So we do, for a PCT application, we go into WIPO. Hopefully we have access to it, and they always provide like the priority information in that PCT application. And then we'll also go to like patent centers to see if the information like matches. Look at the specification, the first page of the specification, and the request form filed. I would just check all of these. I would write down all of the all of the applications that it claims priority to, because sometimes when it's one or two, it's easy for you to make that decision, which one is your priority. It just becomes tricky when it claims priority to another foreign application, and then you have 2 or 3 US applications that it claims priority to. So I would check 2 or 3 different places of where to see this. Go into the patent country website. We can go to WIPO, patent scope, go into the request form, what was filed by the previous counsel, and then the documents that you have been provided by the previous counsel or the client.
Good. And I see several questions in here asking about future programs, and the next slide we'll go to. Oh, actually, let's just jump to that slide next, because that's we'll put that one up with the next programs in this series. So this is the first of 4 webinars on US docketing. The next one is in 2 months. It's on June 3rd, and that one will focus on formalities in particular, which can be tricky. Restrictions and non-final office actions especially. So please go to our website and register for those. We'd love to have you join that. Let's see, I'm just scanning back through some of these questions. Is there a grace period for Paris Convention and PCT deadlines? The answer to that is no. That's why these are such tricky and important deadlines to get right, because if you miss them, you are in trouble. You mentioned that filing deadlines can be verified when another document is received. How do SLW and Black Hills verify that the correct dates are actually on the docket? Is there any automated verification for this? So, well, Black Hills does SLW's docketing. So Z, maybe Ellen and I should take that question. So throughout the process when we're docketing, because we're using automation for our docketing, we're checking critical deadlines in the docketing system to make sure that we don't have any errors on those deadlines. And that's just part of our automated docketing process. And Ellen, I don't know if you want to add any more to that, or if at a high level, we have checks throughout the process that that our systems are looking at.
Yeah, that's exactly what we do. Is throughout every communication, we have different sort of rules and checks that we have, making sure those critical dates are not missed or entered incorrectly.
Mm-hmm. And I just want to say a little something as a client.
Sure.
Oh my God, thank you, BHIP, because you have saved us from critical deadlines going, from a deadline being docketed incorrectly. And because of your verification, you were able to see that a priority date was missing. So I have benefited from that. So thank you.
Okay. What official sites do you use to cross-check dates? So again, from the standpoint of the automation, we're looking at information in PAIR, we're looking at information in Global Dossier, we're looking at information in the EP register. So I guess the answer to that would be the official, the official record type sites would be where we'd be looking to get that kind of information. Okay, we've already explained we're going to be sharing the slides. Those will be coming to you. Oh, here's a good one. And Z, I'm going to pull you in on this. What docketing problems do you face on conversion of a non-provisional application to a provisional and then back again to a non-provisional? So yes, you could definitely, during the period that you have a, that 1 year period, you can convert back and forth between provisionals and non-provisionals. Do you have any tips on how to make sure you get that right when you're making those changes?
So filing from a provisional to a utility or a foreign application to make sure that I'm filing it.
If you change it during the 1 year period, and I think here's what I'm going to throw out, and if you want to add to it, you can. The critical thing, if you convert an application, not do a new filing, but you actually convert from a non-provisional to a provisional or the other way around, I would say the critical thing is your filing type, making sure that the docketing record correctly reflects the filing type, because the dates that are going to launch and the calculation, for example, of an expiration date will depend on whether that's a provisional or a non-provisional application. So I would focus particularly on making sure that filing type is correct if you have that practice in your organization.
And you know what, Anne, you're right. It depends on your system too. We are in Foundation IP, and it's very important what matter type you pick, because if you do like a provisional filing a utility application and you pick NP Reg, it's not going to launch any foreign filing counterpart deadline for you. But if you end up picking that it's an NP new, meaning there's new matter in the application, it will create that 1 year deadline, and especially with the continuation in part, that if you don't end up picking a continuation in part, it will not launch that foreign counterpart deadline. So you definitely do need to be careful what system you're working on. And we have a backup database too, CPI, and that matter type is also important in that system.
Good. Okay, here's a fun one. I might not make a friend with this one. When calculating an expiration date, my attorney tells me to add 20 years from the priority date. He states the priority date should be the earliest utility filing date, even when there is a provisional filed. Is this correct? I got to make sure I'm reading this right, because I read it one way and I thought one thing, and I read it another way and I thought another thing. So basically, you do not include the provisional in the 20-year term. The 20-year term is calculated from the first non-provisional filing date. And I know this because I'm old enough to know when they implemented provisionals, the reason that they implemented provisionals was because there was an advantage to applicants filing in the United States that had an initial filing outside of the United States, because their period for their patent term was calculated from the US filing date, even though they had originally filed a year earlier than that in, let's say, Japan, for example. So it was to level the playing field that they brought provisional applications. Here's another bit of trivia for you. They brought provisional applications into the mix so that you would have the same timeline for a US applicant who filed a provisional application first and then filed a non-provisional a year later. The 20-year term for the US applicant is based off of that non-provisional application filing. So in a sense, filing a provisional has the effect of extending your patent term. You could look at it as a way to extend your patent term by a year, potentially. That was part of the reason behind bringing provisionals into play, was to make that playing field level with somebody who filed overseas first. So you do calculate that 20-year term based on the non-provisional filing date. Great question. Okay, I know we've gone 15 minutes over. There's a few more questions, but I think we've got the main ones. If you can't tell, I am passionate about innovation and technology, and I love talking about automating legal operations. I'd love to talk with any of you about automating your docketing processes, or how you just even start to move in that direction of having automated processes. So please reach out if that's something you'd be interested in. You can also follow me on LinkedIn or on Twitter at Legal Ops AI on Twitter, because I post regularly on legal technology and automation and artificial intelligence. And then, if this is something if automation is something you're interested in, there's another webinar series sponsored by the Schwegman firm that you may want to check out on digital transformation in the legal industry. And this is really focusing on the journey that the Schwegman law firm has gone through over 25 years to transform themselves and to really automate their processes. And Schwegman is now docketing 50,000 items a month automatically, and they're automating aspects of their file opening process. They get instant notifications from their docketing system and to their attorneys and clients when events are docketed because of their automation. Clearly reduction in errors due to data entry, the number of people needed for the repetitive tasks of docketing are less, so that the team that Z has is able to focus on more complex tasks and client-specific tasks. And anyway, the list of things goes on. And so it's a great webinar series going through the journey that Schwegman has gone through in their digital transformation process, and I highly recommend that webinar. So let's go to the last slide. Thank you everybody for participating today. I appreciate you staying on as long as you have, and for taking part in my polls. If you'd like more information about Black Hills IP, you can contact Jim Brophy. If you would like more information about Schwegman, or to get connected with somebody at the Schwegman firm for prosecution, Michelle would be happy to make that introduction for you. So thank you, everybody. Again, I hope you participate and join us for some of these other webinars coming up. Have a great day.